Summit 2020. Well, albeit a virtual summit, of course, considering that we are in a virtual avatar these days. So once again, a warm welcome to all our delegates who have joined in from across the globe in different time zones as well to the 5th Insolvency Summit 2020. My name is Kavya R. Chavali, and I will quickly help you sort of navigate through this entire virtual avatar. We'll be joined by our legal luminaries, stalwarts, and thought leaders as they all come together to focus, to discuss, dissect, and attempt to resolve the problems facing the insolvency resolution framework in these times. Now, before we get the program started, I'm sure all of you who have joined on this platform earlier would also have an idea that there is a discuss button to your right side. The discuss button, I'm going to request you to please use that in case you have any questions for our panelists or for our speakers. So please use that. It's a chat box actually, and it's called the discuss box. So please click on that and please do share your questions with our panelists during the sessions as well. But on that note, I'm also going to take the opportunity to thank our sponsors and our partners as well for their fantastic support. Ladies and gentlemen, for our 5th Insolvency Summit, we'd like to thank our sponsors and our partners, Shardul, Amarjit, Mangaldas, and DSK Legal. And as you're all aware, this program is organized by Legal Era as well. And just to put a little thought into perspective, Legal Era, which is the legal media group, is a leading integrated media company since 2007 to date, and they managed to evolve in very, very diversified ways, in more than one ways than we could anticipate, especially looking at the kind of COVID and the kind of change that we have adapted ourselves to. In fact, they're a proud 11,824 plus members team. And the members also include professional lawyers, corporate counsels, general counsels, arbitrators, CXOs, CEOs, as well as industry leaders. Now, having worked with over 75,000 professionals, their vast array of thoughtful services and slick solutions makes them the only brand serving the legal community with a comprehensive suite of content offerings and services in all the mediums. In fact, their services range from crafting and presenting thought leadership publications such as Legal Era. All of you are definitely aware of it, the IP Era as well, digital products and bespoke information on the businesses, finance, intellectual property, investment fields, and many more. With an international presence in Singapore, South Africa, UAE, the UK, and US, their objective is to serve as India's most credible platform for the global legal community while being a strong go-to bridge between the government and the industry. So on that note, Legal Era proudly presents the 5th Insolvency Summit, wherein we bring to you some amazing set of legal luminaries and thought leaders, and it's time to gather some interesting perspectives from them. So with that, without any delay, I'm sure all of you are joining in for some focus sessions over here. We're about to get started with our first session on navigating distressed investing in the pandemic era. And I must admit that I am truly delighted to have the presence of 3 legal luminaries joining us. We have with us Shri Amarjit Singh Chandhiok, who's the President-elect Bar Association of India, President in Solve India. And in fact, he was the President of Delhi High Court Bar Association for 6 terms, which is a record, as we all know. We also have with us Shri T.K. Viswanathan, who's the Chairman, Bankruptcy Law Reforms Committee. And in fact, as we know that he was responsible for drafting of the Insolvency and Bankruptcy Code 2016, which is the most important economic reform next only to GST since independence. We're also joined by Justice Arjan Kumar Sikri, who's a former Judge Supreme Court of India. He was chosen as one of the 50 most influential persons in intellectual property in the world by leading prestigious international organization for the year 2007 as well. And again, another legal luminary joining us who also has conducted cases of all types with specialization in arbitration and commercial matters, constitutional cases, and many more. So yes, on that note, let's get started with our first session, ladies and gentlemen. And it's only befitting to hear from our 3 legal luminaries who will join us on the main screen in just a couple of seconds. So stay with us and don't go anywhere. So yes, ladies and gentlemen, we'll now have three of our legal luminaries who are joining us in just a couple of seconds on the main screen. And as they come together to share their individual perspectives on this pertinent topic. We will soon be joined by Shri Amarjit Singh Chandhiok, Justice A.K. Sikri, and Shri Viswanathan sir as well will be joining. All three will be joining us on the main screen as they share their individual perspectives, of course, on a very pertinent topic. We already have Shri Sikri sir joining in, and we'll just wait quickly for our two speakers as well in just a couple of seconds. So yes, ladies and gentlemen, we already have with us Viswanathan sir and Sikri sir who have joined us in. Amarjit sir will be also joining us. Please do bear with us. It's all about technology unifying us in these times. So let's stick around for just a couple of more seconds and then we can get our session started. Yes. We're also joined by Chandhiok sir joining in right away. Warm welcome indeed to all of you. And as I've already set the tone for our set of delegates, I'd like to firstly request Amarjit sir to set the tone for the session and to share your perspectives, sir. Over to you.
Thank you so much. My Lord, this is Sikri, the person who laid the foundation of resolution in every part of the law. Then we have another person who laid the foundation for IBC, Mr. Viswanathan sir. And what a privilege for me to share a panel with both these legends in law. Well, good morning to everybody who's joining us today, and hope each one of you are healthy with your families, and pray that you'll continue to do so in these trying times. We have seen wars being enormous economic distress and downfall comes in. So are epidemics, but they have local limitations, maybe state-wise, maybe containment-wise. But pandemic like COVID-19 has proven that it can bring down a confident economic growth, a booming stock market, shoot job layoffs straight upwards and cause recessionary trends to exceed far more than expected economic growth. Healthy companies have lost revenues, their cash reserves dried, and their plight leading to nowhere except bankruptcy, which also we have stopped for the time being. Construction infrastructure, retail, aviation, hospitality, other services and MSMEs have suffered the maximum. The economic fallout because of the pandemic has created enormous stress across the board, potentially affecting their viability and substance. With the debt burden turning disproportionate to cash flow generation abilities, the situation is moving from frying pan to fire. About 5-6 months ago, from the beginning of lockdown, the Reserve Bank of India thought that a resolution framework for COVID-19 related stress must be brought about. And a circular of 6th August 2020, addressed to the banks and financial institutions, referred to as Prudential Framework, was announced on 7th June 2019. But we found that was wanting, that it required the backing somewhere by a statutory, except for the Banking Regulation Act, because some of the people who had pari passu charge with respect to the same are not willing to join the resolution process. Therefore, it gives a setback to that resolution process also under the framework announced by the Reserve Bank of 6th August 2020. And it also, unlike IBC, does not have an overriding power that the resolution plan would then look at something overriding any other contract between the parties. These two things require attention immediately. Keeping the framework in mind, the Reserve Bank also provide a window under the framework to enable lenders to implement a resolution plan with respect to eligible corporate exposures without change of ownership and personal loans. While also, like IBC, a change of management, change of hands is also possible under the Reset Resolution Plan. The framework has been made applicable to eligible borrowers, both corporate, individuals, and MSMEs. With a galaxy of conditions, the stress removal is applicable to all categories. The RBI is also empowered to constitute a committee who will recommend finally, and some guidelines with respect to same are already in place. Under this, the lending institutions have power to allow extension of residual tenure of loan without payment of moratorium for a period of more than 2 years. The moratorium period, if granted, shall come into force immediately upon implementation of the resolution process. Another feature is conversion into another securities and valuation, which provides for conversion of a portion of the debt into equity or other marketable, non-convertible debt securities issued by the borrower. There's a condition here that the schedule and the coupon carried out by such securities are similar to terms and debts held by the lending institution consequent upon the implementation of the resolution plan. We have succeeded somewhere in some portions of implementing this resolution circular. However, what time will tell us now that the situation is changing, lockdown is opening, the lockdown has been removed, to see how further lending institutions take aid of that. Valuation of equity instruments is also another issue and has to be governed by the provisions of the framework. Resolution plans with respect to the accounts where the aggregate exposure of the lending institution at the time of invocation of the process is 100 crores and above would require an independent credit evaluation by any credit rating agency authorized by Reserve Bank of India. These are other features, the accounts involving consortium and multiple banking arrangements, and asset classification and provisioning, reversal provisions, post-implementation performance, disclosures and credit reporting. But unlike we have the IBC, here the corporate debtor himself has not been disqualified and can allow restructuring of itself with the present promoters. As pandemic pressure increases and many companies land into stress and resultant bankruptcy, resolution through viable processes is an option through restructuring, takeover, and otherwise. Many people criticize that by suspending the IBC, we have kept the opening, we put it away for people to use the insolvency to have recovery position. But to my mind, in my opinion, that this is just one portion of not going into restructuring under the IBC, but all other options are still open. And I'm very happy to place on record that during this lockdown, the many times occasions have come when we have utilized what was taught to us by Justice Sikri as a mediator to mediate and see how do we take these things forward. And it has taken a good toll with respect to the same. Many resolution processes have been resolved without even resort to the Reserve Bank of India circular, which I mentioned above. One has to see actually proper identification of this distressed company, opportunities for investment in distressed assets, and attributable to COVID-19 pandemic. One wishes, like Singapore, India would have brought a general law which would have given a force majeure position to almost every economic activity that was happening in this country. For unlike we have Commercial Courts Act 2015, where commercial activity has been defined with a very vast situation. One thought we should have not restricted ourselves to the construction or some other particular activity being done. The government should have brought a legislation or an ordinance by virtue of which it would have brought that position for enabling every borrower, every company to take measure with respect to force majeure. Many of us feel force majeure only leads to something, but to my mind, under the force majeure as defined in many contracts, we have seen stressed assets being transferred to a new company, stressed assets being renegotiated. In fact, the agreements have been renegotiated and have been rewritten during this COVID times. In the recent announcement, SEBI has allowed preferential offer of shares in stressed companies to new owner at a 2-week average as against the formula that considered moving average of 6 months. This could allow potential buyers to purchase existing assets at much fairer value than it was possible either in earlier regulation. Second, again, SEBI has also said that in case of takeover of a stressed or a defaulting company, an open offer is not required from the promoter. This seems to be a huge relief to prospective buyers. These steps are extremely pragmatic towards recapitalizing stressed companies. Amidst pandemic, which is far from nearing an end, these steps will be beneficial in clearing up the existing stock of NPAs and also reduce fresh list of defaulters that would have otherwise popped up as a result of weak economic activity. Separately, Reserve Bank of India has also issued a new rule which makes it easier for banks to sell loans to alternative investment banks. The new set of reforms, along with the existing IBC rules and the jurisdiction of the adjudicating authority, which should soon be available, I hope, would be well utilized by people for restructuring all the stressed assets. The new reforms will allow a fund to participate in not just buying, but also providing recapitalization funds to stressed firms at different levels. The problem potential investors had initially was the prices of shares of the companies which had NPAs or were insolvent. They traded at an unrealistic level, making it difficult for buyers to make an offer, which would not be a case in the new resolution process, which does away with open offer requirements. In the new resolution process, SEBI has clearly defined the parameters of the companies to be assigned the stressed assets. The relaxations pertaining to preferential shares and open offers are not open to misuse by promoters or those declared to be insolvent. For me, the takeover specialists doing due diligence is a must and have a better role and a bigger role to play now in the times of distress. COVID-19 has provided acquisition and investment opportunities. Due diligence is more important than there are advantages or disadvantages of acquiring a company affected by COVID-19 in out-of-court transactions. It may be an attractive feature, and out-of-court transactions entail that business entities in distress needs to be sold and must close the deal as quickly as possible. And here I wanted to, in fact, just before the session began, I was talking to my Lord Justice Sikri to say, time has come that we need to ratify Singapore Convention, which India signed in August 2019, and also a mediation act, because then these agreements which we are signing out of court, we will be able to enforce them in law. Otherwise, without the statutory backing and ratification of that treaty, the cross-border position as well as within the domestic position, that is not possible for the time being to do, unless, of course, we take a recourse, what we have under Part 3 of the Arbitration and Conciliation Act, file a petition before the court and get that done as an award passed by. But most of the time, as the experience shows, that it's a mediated settlement, which is empowering the parties to settle their part. Therefore, I really speaking, it does not merely mean an award. Of course, a consent award is also a concept that is not unknown to law. But if these agreements itself become enforceable in law, then it will be easier for people to enter into those settlements and probably take the economy further towards recovery. The likely choice of an asset sale with the investor pays a fair price is yet another problem that we are facing, and targets assets certain expressly assumed liabilities, specifically disclaims responsibilities of all liabilities. Those big 12 cases gave us a new way to look at that, how people had made acquisitions, how things were transferred out, but some of the have already been ironed out by the right up to this Honorable Supreme Court. I'm sure as the law is evolving, we'll be able to get all this position. To me, a analysis of the district target books and records, as well as a lien, judgment, and pending litigation searches, should arm the buyer with critical information relating to liabilities and that need to be addressed or satisfied at the time of closure. Therefore, the information memorandum, what we talk under the IBC, for example, is not up to the mark. We need to look at that part to see how specialists can help us doing that with respect to our stressed assets, because that will help us to take this situation forward and look at that from the point of view, which is COVID pandemic are arising from variety of sources, we all know, including reduction of equity values, cash needs, payment defaults, regulatory pressures, etc. Those who have thoroughly seen and surge evaluated a pandemic related conditions are still here. Existing models are unsustainable. Therefore, experience in dealing with varied circumstances, resources of fund and opportunities through previously established and new funds are the main ingredients to have a successful execution. In my view, the Justice Dr. Sao's committee is expected to give a report very soon with respect to pre-pack solutions. I hope that can be adopted by the government soon into the legislation. After we will be able to have pre-packs also as part of the stressed assets being done. The second portion is with respect to the asset reconstruction companies must be allowed to participate in the resolution process, as that will help the valuation to take place. We think that remedial measures of saying navigating the distress, we have to consider nature and extent of impact of business from temporary challenges to long-term effects. Loan deferment and interest moratoriums are a good start. Long-term structural changes will have to be considered. There has to be scrutinization among the government, lenders and promoters, and all these stakeholders. While some of the distressed businesses will recognize, others may not, the unsuccessful will provide the opportunities to those with capital to purchase assets with protection afforded by adjudicating authorities. In the light of a tunnel that now mediation is being considered as capable, as I mentioned earlier, resolving insolvency, including cross borders, time has come that we should adopt the new rules. Time to promote the same is now, as is rightly participatory, begins and ends with a win-win situation. With new normal, it is time for us to change the change, and we can only bring it if all of us were to participate collectively and look at these stress assets to see how we can take the country forward from this distress situation. And I am sure we have passed through many challenges. This country has history to overcome challenges. We have potential to meet all these challenges. And I have no doubt in my mind, looking at the strength that we have in this country, the talent available at our sources, we shall be able to overcome these challenges. And soon the economy shall be back to recovery. Thank you very much.
Thank you very much, sir, for sharing your dynamic thoughts and the way you actually, summed it up by saying change the change and how we can actually achieve that collectively. Thank you so much, Chandhiok, sir. On that note, well, after that opening address, we'll now move on to a special address by Shri T.K. Viswanathan, who's the chairman of Bankruptcy Law Reforms Committee. So, Viswanathan, sir, with that, over to you.
Thank you, Kavya. Good morning, Justice Sikri, who has given us international fame all over the world with being the part of Singapore Arbitration Court, and Justice. Then he has been a leading forefront in almost all reform measures, starting from the arbitration, mediation, and almost in all commercial matters. Justice Sikri's views are sought after, and his contribution to Indian jurisprudence and commercial is very valuable, and it has been globally recognized. Thank you, sir. I deem it a great honor to share a podium with you. Last year, we were there in Mumbai. At the same time, we were sharing the last year's summit. We missed this year. Probably next year, Agriti will make it possible. We will soon meet. Chandhiok, yes, for a brilliant inputs you have given. Definitely, these are things which we taken up. Let me just start with a short recap of the road travel, just to refresh our memory, because I've been too long involved in this process from 2014, and I've been watching how this code has been moving around. The code has traveled well. It has traveled well. There is no other legislation in the Indian statute book which has been so carefully attended to and amended, and it is continuously being monitored. I would say this insolvency in the bankruptcy code is a jewel in the Indian statute book, because like the Indian Penal Code, which was envisaged many centuries ago, it has consolidated the laws related to credit market. It has brought a single forum, and it is now laid a new foundation of a new bankruptcy jurisprudence. Any law which is bound to create new hurdles and new problems, because we are all in the process of learning. And especially in the modern times with the digital technology and knowledge revolution, legal knowledge is becoming obsolete overnight. Very difficult to keep abreast of the challenges. The regulatory laws are becoming belted out by the regulatory agencies. It keeps changing. It's very difficult to keep track of what's happening, and every new law creates a new issue, leads to the court, and then it creates new challenges which we have to handle. All of you know that we conceived this insolvency and bankruptcy code as a restructuring mechanism, not as a recovery mechanism. But unfortunately, to some extent, this has been distorted because this has been used to recover debts. This has never been our idea. We wanted to restructure the existing business. We changed the test to find out the network erosion. We changed it from network erosion test to inability to pay test, and we brought in a lot of other changes. Now, this pandemic is not confined to our country alone. It's a global phenomenon, and all the countries have tried to deal with it in their own way. Our credit market, our Indian economic situation is very complex. It's very difficult to address the way in which US or Singapore have addressed it by a single law, because we have too many players, too many stakeholders, and it's simply impossible to have one size fitting the shoe. That's impossible because we have to take care of so many interests. We have social problems. Anyway, this pandemic hit us very bad, and then the government also responded by bringing in an ordinance. Now, the point remains, any law for that matter cannot be perfect. It cannot be comprehensive. The ordinance was not really comprehensive. It has created a certain amount of uncertainty also, because if you were care to see the ordinance, I don't know whether you have read the ordinance, or normally amending ordinances or amending acts do not contain a preamble. But this ordinance which is promulgated, this Insolvency and Bankruptcy Code Amendment Ordinance to respond to the pandemic situation, contained a preamble. You know what happens when you say something in the preamble, give the reasons for enacting it, then it becomes justiciable. Now let us see, for your refreshing your memory, let me read out from the ordinance, the preamble to the ordinance. It says, whereas the entire ecosystem for implementation of the Insolvency and Bankruptcy Code is in place, and whereas the provisions relating to corporate insolvency resolution process and liquidation process for corporate persons under the code are in operation, and whereas COVID-19 pandemic has impacted business, financial markets, and economy all over the world, including India, and created uncertainty and stress for business for reasons beyond their control, and whereas a nationwide lockdown is in force since 25th March 2020 to combat the spread of the COVID-19, which has added to the disruption of normal business operations, and whereas it is difficult to find adequate number of resolution applicants to rescue the corporate person who may default in the discharge of the debt, and whereas it is considered expedient to suspend under Section 9, 7, 9, and 10 of the Insolvency and Bankruptcy Code to prevent corporate persons which are experiencing distress on account of unprecedented situation being pushed into insolvency proceedings under the code for some time, and whereas it is considered necessary, expedient to exclude the defaults arising on account of the unprecedented situation for the purposes of insolvency proceedings in the code. Then they inserted Section 10A, suspending wholesale 7, 9, and 10. And then, if you read the ordinance and also the act which has replaced it, there is some issues relating to how the wording of the section itself. If you see, there is a proviso to 10A which gives an impression that it has extinguished the whole cause of action during this period, which is not the effect. And in fact, the courts will have to read it down. This is still in the act. Now, having said that in the preamble to the ordinance, now what happens? The ordinance itself has been replaced by the bill, by an act of parliament recently. The preamble is not there. In the replacement act, the preamble is not there. But then you have only an SOR, the statement of objects and reasons, where the finance minister, she says the reasons for why it has been done. The same in the light of the extraordinary economic situation caused by COVID-19 pandemic, a need was felt to temporarily suspend initiation of corporate insolvency resolution process, initially for repairs, etc. She gives that in the SOR. But the preamble I told you refers to the non-availability of resolution professionals. She says so many other things. Now, when you start giving out reasons, then then it gives rooms for people to litigate on these grounds. I'm not sure whether this has thrown any additional value addition to this the ordinance is written. Secondly, barring these corporate debtors from invoking the resolution process, I think is not a wise move. They should have barred, of course, 7 and 9. 7 and 9. 10 should have been at least left for the corporate debtors who wanted to restructure. Would have approached the insolvency and bankruptcy court if they find that is advantageous to them. And that should have been synchronized with the Reserve Bank programs of restructuring of debts. You see, that would have brought the entire scheme under the statute, under the IBC, and it would have seen more people coming out with resolution and restructuring. Secondly, most of these companies, corporate creditors, should have been incentivized to approach the restructuring under the outside the code, so that it is easy for the corporate debtor to come out of this mess, and that could have been instrumentalized into the act itself. These are some of the things which we can think about it, even it's not too late. But the point remains is we do not know the impact of the suspension which has taken place for this period. It may have some long-lasting impressions for the simple reason whether we to relate some distress to the pandemic or it's independent of the pandemic. It is very difficult. That should not be a question which should be decision. It becomes a problem. Something may not be induced with pandemic. It may be otherwise also distress. Then how do you deal with that? No, Justice Sikri is the forefront of popularizing mediation. So mediation now is a substitute for arbitration. Nobody wants to go to arbitration because it's very expensive. And mediation is required to be involved in this IBC process, as Chandhiok has rightly said. And that has to be given some statutory recognition so that it has the same force as the resolution plan. So these are all some of the things which we have to address to see how this IBC can be made more effective to deal with this financial stress. And these asset reconstruction companies, they should be involved in the asset revision. By and large, this is a new law, and we are all in the process of learning, and new expertise is emerging. It is expected. Because when we drafted the code, many of the MPs were very skeptical. They were asking, why are you bringing in all these things? From where you will get all these professionals? It's all new. Where are you? Where is it? I said, this will happen. Everything is, but it's rapidly evolving. And I'm very sure with the guidance of conferences like this, where Sikri is in the forefront, definitely a lot of these people will come forward, put forward new suggestions, and the government is very willing to take, because no other law has been continuously monitored as IBC apart from Income Tax Act. Because I have been in the government for a long time. The Income Tax Act we amend every year in the finance bill. The Central Board of Direct Taxes have in the fingertip data. They know which section it will touch, how much will be the revenue inflow. We have a similar thing for the IBC. We have a standing committee and we are continuously monitoring it. And whatever Chandhiok says in the court, we hear. So we are very sure of responding to the difficulties which are faced. I'm very sure no law can be very perfect. We cannot anticipate. And as Justice Scott Deso said, the sordid controversies are the stuff whatever the shining truths will emerge. It is very nasty things, this insolvency in bankruptcy court. But then in the long run, when the jurisprudence evolves, we will be seeing a very bright future. As you said, our country is a great country and we withstood many challenges. We will overcome this also. And I'm very sure that with all the stakeholders contributing, we will take this IBC forward. And I'm very sure this IBC has not been a failure. Many people were very skeptical in the beginning. Your act will not see the daylight, it won't work. It has worked, it has withstood challenges, it withstood the legal challenge from the highest court, and we have eminent people here who carry forward this baton. Thank you and congratulate Akriti of Legal Era for making this possible. Thank you, Justice. Thank you, Chandhiok.
Thank you very much, Viswanathan, sir. On that, Quickly, we'll now move on to the keynote address by Justice A.K. Sikri, who's the former Judge Supreme Court of India. So it's now time to get your inspiring thoughts, sir. Over to you.
Thank you, Kavya, and good morning to all who have come here to attend this seminar, webinar nowadays. This is new normal. Instead of seminar or conference, we call it webinar. And I congratulate Legal Era for organizing this. And I thank both Mr. Viswanathan and Mr. Chandhiok, not only for their kind words, but they have already said whatever could be said and have set the tone as far as this webinar is concerned. Yes, everybody knows, and this the kind of situation which COVID-19 has brought. It is like any, in 2008, we had a world recession, but which was for certain other economic reasons. And here something which where nature has played havoc. And because of that, as it is said, the three things which are affected: lives, livelihood, and lifestyle. There are many lives which are, lost because of COVID. Livelihood, it has generated, or it has, aided so much of unemployment. And lifestyle, which we are witnessing now, as Mr. Viswanathan rightly said, that instead of all in Mumbai and physically present and in person holding this webinar, we are on this virtual mode, sitting in our own places, houses, and this is new normal, and this is lifestyle, and where we are asked to wear mask and have this social distancing, etc. So in these, when this is the effect, and virtually lockdown in the entire world, because the effects of the adverse or ill effects of COVID-19 have been phenomenal, and it is not one or two countries or few countries which have faced. Virtually every country on this earth, the entire world has faced it. And naturally, if there is going to be, as I said, the three things: loss of lives and livelihood and change in lifestyle, it is but natural that it will have adverse effect on business as well, and where the IBC kicks in. And if I may say in very short, that according to IMF, International Monetary Fund, the global economy is expected to shrink by over 3% in 2020. This would be the steepest slowdown since the Great Depression of 1930. So almost after 90 years. So this kind of thing which is going to happen. The world is facing humanity's biggest crisis since World War II, which has put the world economy at a major risk, ravaging the economic foundations of the world trade. Commentators have identified this outbreak as an outcome of hyper-globalization or starting of deglobalization. However, the world is going to face recession, and the global losses, according to some commentators, may exceed the World War I and World War II combined. Now, this is going to be the effect of this. Out of all economic shocks, consumer hysteria is most lethal, because they are if the consumers don't come forward and the demand is not generated, as we have read in the economics also, it is going to affect the business all around, and which has been happening. Panic and fear has a pervasive effect on the market. The impact is not only limited to the demand side of the market, but the availability chain is additionally hampered equally because of lockdown conditions and so much which has happened. If I may say so, this has the three kinds of effect: that directly affecting production, then creating supply chain and market disruption, and then the financial impact on firms and financial markets. So these are the three major offshoots of this pandemic, which are creating the situation, the market situation in which we are. And it's almost now 6 months into this pandemic, and the influence of COVID-19 on personal and economic health and its effect on our daily lives presage uncertain months ahead. We don't know what is even today till the time vaccine comes, that what lies with us in future, and its effect on our this we have almost accepted, as Mr. Chandhiok also said, that this altered reality is new normal, and we are gearing to adapt to this new normal. As it is said that necessity is the mother of invention, and we witness ingenuity born from this crisis in all our aspects of this personal or professional lives. We have to find solution under these conditions. Now, if I may say so, and this adaptability, and which is very, very necessary, that of the new normal, and I'll say on that a little more later. But then it has brought many positive changes as well, insofar as the ecosystem, legal system, etc. is concerned. If I may little digress from this IBC topic, and highlight it, that it is bringing and it has brought many sweeping reforms in our judicial system, in our legal system. We are adopting technology in a big way today, because there can't be physical hearings, although the attempts were made because of the demands of some bar associations that there should be physical hearings, but people did not come forward, neither the litigants nor the advocates. So still the hearings are taking place on virtual mode through video conferencing, and this adaptation of technology is leading to transformation. And we are coming out with what is called ODR, online dispute resolution, because all this becomes relevant in the context of our insolvency proceedings also. That is why I'm hinting at that. And today the Niti Aayog has undertaken a project as to how, even if we return to the old normal over a period of time, how technology can still be used, and we can continue with the hybrid system of virtual hearings as well as physical hearings at the same time, in order to take advantages of that. And as far as ODR is concerned, online dispute resolution, it is not limited to only the court hearings. It is not limited to the arbitration or the mediation. Rather, some of the startups which are coming, and some kind of disputes, and most suitable disputes are the insolvency disputes of MSMEs and consumer disputes, etc., which can be taken up online, even if physical hearings take place tomorrow, and how they can bring a sweeping change in the legal system. So all that is happening. And at the same time, as I said, that because of these reasons, we are facing, insofar as business is concerned, it is facing crisis all over the world. And therefore, things are being discussed. Of course, Indian government and all other stakeholders, they sprung into action well in time, as although this threshold of 2 rupees 1 crore, which was being talked of earlier, and it is not result of COVID, but it happened during the lockdown. This step was taken, and as Mr. Viswanathan and Mr. Chandhiok has already said, that the suspension of corporate insolvency resolution and this process with the passing of new provisions bringing Section 10A in the IBC, where Section 7, 9 and 10 have been suspended. It has its advantages as well as disadvantages also are discussed. Mr. Viswanathan has already mentioned that at least Section 10 should not have been suspended, and that is one view which has been very majorly which is prevalent, because Section 10 provides for defaulting company to submit itself to CIRP, and why they should not have been allowed to do so. Apart from that, NCLAT immediately, say in April itself, it was on this 30th March 2020, in a suo motu company appeal, they passed the order extending the waiver to the overall time limit as well, that is beyond 330 days, that during the period of the lockdown period would be automatically excluded. And Mr. Chandhiok has already said, and I need not repeat, as far as IBBI regulations are concerned, and so many amendments are made in that direction. Actually, I'm not going to say much about the as far as the culture which has developed and the way the issues have to be resolved, as I wanted to say, but then the ground is already covered by my worthy predecessors who have spoken so well. But as I said earlier also, that look, it is very, very important to adapt to the new times or the new normals. As somebody has said, it is not the strongest of the species that survives, nor the most intelligent. It is one that is most adaptable to the change. And what is with the suspension of IBC, and the first change which is required is, as is stated by both the speakers earlier, and I like to highlight that is the mediation, which is now the way out insofar as resolving so many disputes. It is good thing is that our IBC code itself recognizes the mediation. Of course, what start with the amendment in the CPC by insertion of Section 89 in way back in 2002, and the way in last 15 years mediation has taken strides in this country, and we have always been discussing about this mediation is would be not only successful, it is one of the prime mode of settlement of disputes insofar as commercial disputes are concerned. And commercial disputes, as Mr. Viswanathan also said, that sometimes, of course, arbitration is also one of the cherished mode, but then in so many respects and in the so many circumstances, mediation can prove to be better than even the arbitration. Realizing this, if you see after COVID, and it started happening even before COVID also, most of the arbitration centers, international arbitration centers, be it SIAC, be it LCIA, be it ICC, or all others, they have started including the clause of mediation. And that is why there is med or med etc., so that the mediation should be made use of even before going to the arbitration. And in a case like where the insolvencies, problems are going to be there, arbitration is not a solution, but mediation is definitely a solution. Industry need to internalize the dispute avoidance. That would be more important in a situation like this. Internalize the dispute avoidance, having mediation clause and mediation culture. It was said by Mr. Chandhiok about the Singapore Convention. Actually, even as far as India is concerned, for last 4 or 5 years, it has been discussed, and even the Law Commission had given the report that we need an act on mediation for so many reasons, which it is not necessary to state all those things here. Even one day before I demitted the office, in one of the judgments, I emphasized and I rather provoked the government to come out with the legislation which is necessary. But it has become all the necessary after the Singapore Convention and facing these COVID-19 conditions. Because today it is not only the mediation which is required or mediation law which is required for the purpose of settling the disputes which are domestic disputes and finding a resolution about that, but when this COVID conditions are going to have impact which has cross-border impacts. And in India itself, even before COVID, in some of the cases, we have found that we are now having where the cross-border ramifications are there, and that is why Mr. Viswanathan had been the chapter which was missing of about cross-border insolvency in our IBC had worked on that and had given his report also, but we are still awaiting that legislation. But now, when we are talking about the settlement of these disputes or even insolvency problems at international level as well, and once the settlement takes place at in international disputes, where how to ensure that the settlement becomes binding settlement, Singapore Convention is aimed at that. So therefore, like an arbitration act where we have our domestic arbitration as well as international arbitration, and the binding nature of the awards in arbitration is taken care of by New York Convention, etc., or Geneva Convention. In the same breath is the Singapore Convention, which is again UNCITRAL's baby, and since it was signed in Singapore, therefore it is called Singapore Convention. Good thing is that India was the first country, along with others, which was signatory to this convention, but we have not ratified it so far. We have not come out with any legislation. But this development, I would say, has given us a chance to come out with a comprehensive legislation now on mediation, which takes care of domestic mediation also, and which takes care of international disputes as well, which are settled through mediation. And COVID has shown us the way that it has to be done, and the time has come. There's so many aspects. Actually, Mr. Chandhiok had mentioned about this IBC. I'm not going into that, which are facing. But at international level, and when it comes to many other topics, the questions which arise in this context are: is there need to suspend bankruptcy proceedings for certain period, which has happened? That question, as was discussed by both the speakers, its pros and cons. What are the paths to turn around the crisis when there is a suspension of those proceedings? And mediation is one such thing. Tectonic changes that are required in insolvency regime. We have made some, as I said, that Section 10 is inserted, but example was given. Singapore has come out with law to meet this situation. And there are discussion at international level about the Singapore, whether Singapore is ahead of all others and is able to take care of the situation by passing such a law. So therefore, do we need to have a comprehensive law on this? The practical changes arising from the crisis, practical challenges arising for the crisis. What are those challenges? Though these are the topics which need to be discussed. Impact of pandemic on SMSEs, which is again discussed by my earlier speakers. The strategies and trends in current environment. What kind of strategies which are required? Because it has to be out of box thinking, and the lessons which we have learned and the ideas which we have gained, and it can be through these kinds of conferences. And this is one of the topics also, and again discussed at international levels, is distressed investing in pandemic area, which is taking place all over. So, and another thing which I would say here, that maybe today for 1 year, as far as proceedings, IBC proceedings are concerned, these are suspended. But there's going to be an explosion of the litigation before the NCLT once this period is over, and we come back to whether we come in a new normal or we come back to old normal. And at that time, what should be the judicial approach? This is going to be a challenge for the members of the NCLT. And in these circumstances, when the issues would come before the NCLT, which are COVID driven, and where the some companies have gone or would be going or would be facing the litigation, going insolvent, or would be facing the litigation in the NCLT, and what should be the approach in those circumstances, as well as judicial approach, and the how case management is to be conducted in those circumstances, what should be the best practices. It is going to be a challenge, and therefore our judicial member, or whether judicial or administrative members of the NCLT and NCLAT have to gear up to this challenge. I think they should start preparing. They have got the time now because of lesser work today, and they should start preparing to meet this challenge. This is again one of the very, very important topic, and very, very important area which needs to be addressed. Mr. Viswanathan rightly said, and who is the father of insolvency regime in this country, and being the chairman of this committee which framed IBC, he said that main purpose of the IBC is restructuring and not the liquidation. That has to be kept in mind. And as I say, I always quote Shakespeare, who said that some people are born sick, some acquire sickness, some people are born genius, some acquire genius, and on some geniusness is thirsted upon. So likewise in our business world, we say that some companies, they are born sick, in the sense that from very beginning the idea of that business which was conceived was wrong, and there was no takeoff of those businesses. Some acquire sickness, and on some sickness is thirsted upon. So these are those when the sickness or the insolvency conditions or the losses can be because of the mismanagement and malfeasance, etc., of the directors, but it can be because of economic and other market conditions over which the business enterprise had no control or no role into that. COVID-19 is one such condition. So therefore, in such conditions, what should be the approach of the judiciary or the NCLT? This is very, very important. So therefore, all these aspects would be discussed in this conference. I congratulate Legal Era again for holding this conference on very, very important topic, because on this depends apart from many other measures which can be taken to revive the economy, which has suffered a great setback. Good thing is that in last few days we are seeing in this country some revival, some hope. And I would again borrow the words of Mr. Chandhiok, who said that we have the capacity to fight any kind of adverse situations, and we have always emerged victorious in these things, and we will be able to do as far as COVID-19 also is concerned, we'll able to meet this challenge, and IBC in the whole process becomes a very, very important aspect which has to be taken care of. So I hope that there are going to be very good discussions, and whatever is the outcome thereof, and some innovative ideas which come, which should be shared not only among the those who are participating, but it should go to the policy makers also. Thank you very much.
Thank you so much, sir. Thank you, Sikri, sir, for not just sharing your thoughts around the framework, but also adapting it to how we are dealing in terms of our life. And also the fact that all the three of you have come together to give a head start to this Insolvency Summit with your visionary thoughts. And I'm sure that we're looking forward to some very interesting sessions as well from the rest of our speakers after you all set the tone. So I'd like to thank you all humbly for joining us this morning. Thank you very much indeed. And with that, we will now be proceeding to our next set of sessions, ladies and gentlemen. And thank you, and we hope to see you again in our next edition, but live. Thank you again.